Hey everyone, welcome to my case summary of Palsgraf v. Long Island Railroad Company. This is a big one for tort law, and boy is it a bizarre case. If you're in a torts class, you are almost certainly going to read this case. So it's an opinion by the wacky Judge Benjamin Cardozo. It's from 1928, and it was decided by the New York Court of Appeals. The fact pattern is crazy. Mrs. Palsgraf was standing on a platform at the defendant's railroad company. When a train stopped at the station, two men ran forward to catch it. One of the men got onto the train easily, but the other, who was carrying a package, seemed unsteady, like he was going to fall to the ground. So a guard at the railroad reached forward to help him, and another guard pushed him from behind, which caused the package that he was carrying to dislodge and fall from the rails. And guess what was in that package? Well, the package contained fireworks. Yeah, boom. So there was nothing in the on the package, anything that gave the appearance that it had fireworks in it. Nobody could have known. The fireworks exploded after falling, and the explosion from the fireworks threw some scales at the other end of the platform, which then struck Mrs. Palsgraf pretty badly, injuring her. So she, of course, is going to sue. I mean, who wouldn't want damages for an injury like this? So Cardozo writes the majority opinion. He says that the conduct of the defendant's guard, if a wrong in its relation to the holder of the package, was not wrong in its relation to the plaintiff, who was standing far away. Negligence is not actionable unless it involves the invasion of a legally protected interest, the violation of a right. So I think this next quote, directly from the case, is an outstanding summary of the principle. Negligence, like risk, is thus a term of relation. So he's pointing out they could have had no idea that this would happen. The guard had no idea this would happen. And yet, probably the guard should not have pushed this gentleman onto the train. He probably should have been careful, but he never could have foreseen that there were fireworks in that package, nor could he have foreseen that they would have exploded, causing shards to fly out and hit Mrs. Palsgraf in the way that they did. And of course, there's a dissent too. This is Justice Andrews. Everyone owes to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others, he writes. When unreasonable risk is taken, its consequences are not confined to those who might probably be hurt. So the idea is, don't be an idiot, don't be negligent. It doesn't matter if the injuries that resulted from an unlawful act are unusual, unexpected, unforeseen, or unforeseeable. And he says that under these particular circumstances, he can't say as a matter of law that the plaintiff's injuries were not the proximate cause of the negligence. So yeah, Andrew's dissent obviously makes a lot of sense, but also Cardozo's kind of got a point. It would feel kind of wrong to hold the railroad liable for this. So the important takeaway is that if the plaintiff was not foreseeable, then that's going to be a major roadblock for the plaintiff to recover. That is dangerous territory. Still, just because he was in the minority, Justice Andrews' dissent is widely respected and is actually the view of the third restatement of torts. Like, there are some courts who actually treat Andrews' dissent as the law. They think that he was right, and that's the way that they govern. That's how they decide. But yeah, that's Palsgraf versus Long Island Railroad Company. I hope that you liked this video. I hope it was helpful, and I hope you get an A+ in torts, or if you're not in a torts class, that you found it interesting. So if you found it helpful, interesting, or insightful, please leave a like, comment, or subscribe to the channel. Let's grow this channel. I really do appreciate it. And as always, thank you for watching.